Alrighty. Welcome everyone. My name is Corwin Cruz. I am a family law attorney. I'm based in Minneapolis. And today we're going to discuss divorce law for non-family law attorneys. We are going to be covering quite a bit of ground today, looking at a lot of things, moving fairly quickly. Feel free to ask questions if you have them. That's fine. If you want to copy the slides at the after this, you can contact me. I'd be happy to email them to you. If you have a question or anything after the fact, feel free to give me a phone call and email. I'd be more than happy to talk to you about it. The goal today is not to make anybody an expert in family law by any means. My goal is to give you a basic understanding of some of the concepts involved and the process, so that if you have a client who may come in for some other reason and starts talking about divorce, at least you can be conversant about it. Maybe you can answer a few basic questions and know when it's time to send them off to a family law attorney, right? Also, this discussion is going to apply to same sex as well as other sex marriages. I'm probably going to typically talk about him and her, but realize that gay lesbian marriages will also be included in all of this, right? I want to begin by distinguishing between several ways can end or be altered in Minnesota. First, obviously, divorce. That's going to be the primary focus today, but also legal separation. This is distinct from divorce, but many, if not all, of the concepts that we're going to talk about today are going to apply to legal separation as well as divorce. So do keep that in mind. And then finally, annulment, which is very rare, but at least you should be aware of it. All right, first, divorce. Not too surprisingly, a divorce terminates the marriage. That's probably obvious to everyone that's here. In Minnesota, as in most, if not all states, divorce is no fault. And historically, if you wanted to get a divorce, what you needed to do was show that somebody had done something wrong. Maybe they had an affair, they were abusive, they're a chronic alcoholic, something like that. That's no longer the case. It's no fault. And the basis for it per statute is that there's been a, quote, irretrievable breakdown, end quote, of the marriage. This is the sole basis for a divorce in Minnesota. Now, sometimes you might read the paper and they breathlessly report that some well-known Minnesota couple got divorced. And the only reason listed was that there was an irretrievable breakdown, and they, as if it's some big secret. Well, yeah, that's going to be the basis for it because that's all there is. So they're not trying to hide something by saying that. Because of this, only one party needs to desire the divorce, right? You're not going to be kept in a marriage that you don't want because your spouse doesn't want to get divorced. Most of the stuff we're going to talk about today is in chapters 518 and 518A of the Minnesota statutes. If you want more detail, you can certainly take a look at those. The second concept that I do want you to think about is that of legal separation. This involves the courts. It's more than just living apart. I occasionally get phone calls or somebody coming into the office and they'll say, oh yeah, we've been legally separated since June, but we decided we wanted to get a divorce now. Almost invariably, what they actually mean is that they've physically separated. They're living in other places, right? That's not legal separation. Legal separation actually decides most of the legal issues. You can have spousal maintenance in legal separation. You divide property. You might determine parenting time. All of those things. It's more than just living apart. Basically, it's like a divorce, except you're still married. You can pretty much do everything else. And generally, a legal separation takes just as long as a divorce, and it costs just as much as a divorce. That tends to surprise a lot of people because they don't really understand what a legal separation is. So given that, why would anybody choose a legal separation over a divorce? Well, there are two primary reasons that I see. Now, there may be others. People do things for all sorts of reasons, but these are the two that I see coming in. Legal separations, I would say maybe one time a year I handle one of those. We usually handle divorces, but you do occasionally get these. The first, religious beliefs, all right? Some religions discourage or maybe even officially prohibit divorce, and if the couple is very observant, they might want to do everything except end the marriage. You know, they want to resolve all these other issues, but they don't want to end the marriage. Had a couple that was a very conservative Catholic couple, came in. They really believed the idea that the Catholic Church has that you should not get divorced. So they got a legal separation to get around that issue. The second reason is, that I've seen at least, is a desire to maintain insurance. Now with the Affordable Care Act, this, and who knows if that's going to be around a year from now, I don't know, that may impact this. But I have seen couples come in, and because somebody had a pre-existing condition that was fairly severe, they wanted to keep them on the other spouse's insurance. For example, maybe 2-3 years ago, had a client whose husband had ALS, Lou Gehrig's disease, fairly advanced. He was in a home, cost $8,000 to $10,000 per month for his care. And both of them were concerned that if they got divorced, he'd no longer be on her insurance through work. Would they be able to afford this? Would they be able to get new insurance quickly enough because they couldn't afford to pay during the gap time? So they decided to get a legal separation. Now, one thing to keep in mind that you should discuss with clients if you are talking about this is that a legal separation versus a divorce is going to impact inheritance rights. If you look at section 524.2-202, that is the elective share statute. If you're married, you cannot be cut out of the will, right? If somebody doesn't leave you what you think you deserve as a spouse, you can take what's called an elective share, a certain percentage of the augmented estate. That amount, that percentage, increases every year up until 15 years of marriage, at which it becomes 50%. If you're divorced, that no longer applies. You can cut somebody out of the will. You know, I don't know too many people who would keep them in the will anyway after a divorce. Yes, sir.
Would you incorporate that type of issue in separation agreement then, or just separately do estate planning?
I would send them off to an estate planner to do it. I don't do trusts and estates. I don't want to do trusts and estates. Not that that's bad. It's just not my cup of tea. So I would send them off. But the thing I do mention to people if they are considering a legal separation is that you're still married, so you're still building up those years to get that elective share. And so that may be an issue you at least want to think about. So yeah, I think sending them to an estate planner would be a good idea. And then finally, annulment, the let's pretend this never happened type of idea. This is very rare. I've never actually had anyone come in and ask me to help with an annulment, but they are out there, so you should be at least aware of them. Very strict statutory bases for this, okay? The first is a lack of capacity to consent. That could be because of some sort of mental limitations. Maybe you have cognitive disabilities that limit your ability to consent to things. That would be one reason. Alcohol or drugs, all right? These stereotypical, we flew to Vegas, I got really drunk and got married and didn't really understand what I was doing. Okay, you can get an annulment for that. And force or fraud. If you're coerced into the consent, you can still void the marriage if you want. The second is an inability to consummate the marriage. This only applies if you were unaware of that ability at the time of marriage, all right? So do a little investigation first, so you don't have to worry about this. And if you're under the legal age. Legal age in Minnesota is 18 or 16 if you get the permission of your parents, guardian, the courts, something like that. Right, so now that we've discussed these three ideas, who can petition for a divorce in Minnesota? Well, the primary requirement is a 6-month residency, all right? You move to Minnesota, you have to be here 6 months before you can get a divorce in Minnesota. That's only one of the parties, all right? As long as one of the parties lives here, you can do that. So 180 days. You can, however, be in the military and stationed somewhere else and still file in Minnesota if you kept your Minnesota residency. So you kept your Minnesota license, you have a house in Minnesota, you plan to return here. So even though you're stationed, you know, you're in the Navy, you're in Norfolk, Virginia, you could still file for divorce in Minnesota. Now that would raise a question of whether you would want to, because you want to have to come back to Minnesota if you have court appearances, but you can do so. And then the issue of venue, one of the parties has to live in the county that you file in, all right? So you're either going to have one or two choices for the county. If you both live in the same county, that's where you file. If you live in different counties, you can file in either one. If one of you lives in St. Paul and one lives in Minneapolis, that may not be a big deal. But if one of you lives in Ramsey County and one lives in Crow Wing County, you may want to get in first and file in Ramsey so that you don't have to drive up to Crow Wing County if you have to go to court. Want to spend some time thinking about the most common issues that we deal with in divorce. Keep in mind that all divorces are different. Not all of these are going to be applicable in every case. I'm just going to go through them all quickly first, and then we'll look at each in a little more detail. All right, custody, parenting time, child support. Obviously, if you don't have kids, these are not going to be an issue. If you do have kids, these become very, very important. Spousal maintenance, some people still use the word alimony. Officially, it's spousal maintenance in Minnesota. Division of marital property, division of debt, and my favorite, attorney fees. Okay, it becomes very important if you want to make a living. So we're going to look at these in a little more detail. Let's start out by thinking about custody. All right. Now, there are two kinds of custody in Minnesota. Either one of these can be sole or joint. The first type, and the most important of the two, or the more important of the two, is legal custody. What legal custody is the right to make decisions about major life events. Statute specifically refers to three different things. Okay? First, education. Where are they going to go to school? Second, religious upbringing. What faith are they going to be raised in, if any? And third, medical. Now, this relates to things that are elective. It's not an emergency. If you have an emergency, somebody pushes your child off the merry-go-round at school, they break their arm, you don't have to go and talk to the other parent before you bring them to the hospital. Here, we're talking about things like, should they be on ADD medicine? Are they going to get some sort of elective surgery, that type of thing. If you have joint legal custody, the statutory requirement is that you confer with the other parent. You have to talk about it. Doesn't mean you have to come to an agreement, although if you don't, you may end up in mediation or in court or something like that. One of the most common reasons that we tend to see people going to court when they have joint legal custody and can't agree is school choice. Which school are we going to send our child to? I want to send them to St. Paul Academy. You want them to go to Central. All right, which one are they going to go to? Somebody has to make that decision. If you can't decide, you may end up in court. The other type of custody per statute is physical custody. Yes, sir.
Will the court really adjudicate what faith the child is raised in?
They can say, they're not going to say this child has to be Catholic, but they can say, yes, when you're with this parent, that parent can take you to church, this parent can take you to synagogue or mosque or whatever, that type of thing. I don't think I've ever had anybody file a motion over religious upbringing. It tends to be education. I have seen one medical about vaccinations. That can be an issue. Okay. Physical custody doesn't have a whole lot of practical meaning in Minnesota. The more important issue is parenting time. Now, physical custody may still be important, the label, whether it's sole or joint. If you move to another state, that still puts a lot of emphasis on that label. The one time I have seen it make a difference in Minnesota was with home district priority for school enrollment. You can go to pretty much any school you want, but you tend to get priority in your school district. If you have joint legal custody, most schools will consider that to be two different, you can have priority in either one. Sometimes, not always, but sometimes I have seen schools where somebody has sole physical custody say you only have priority in the district that that person with the sole legal custody lives in. That's not always the case, but just realize that that is a possibility. That's really the only major thing that I've seen physical custody have much of an impact on. So I'm going to turn then, as I said, the more important issue is parenting time. So I'm going to turn to that now. This is often the subject of substantial disagreement. Okay, who gets how much time? How's the schedule going to be structured? Those sorts of things. Now, in Minnesota, by statute, each parent is presumed to get at least 25% parenting time if the issue is raised to the court. There have, for the last 3 or 4 legislative cycles, been attempts to raise this to 40%, to 50%. None of those have gone anywhere at this point. They may or may not in the future, I don't know. But at present, each parent is presumed to get at least 25%. Now, what this is equivalent to is 4 overnights out of a 2-week period. Okay. If you have a 2-week period, each overnight is about 7%. So to get above this would be 4 overnights. Now, you can certainly stipulate to less than this. You can stipulate to a lot of things that the court can't do on its own. You can stipulate to less time. The court can order less than this if they make findings to show what the rationale is. You know, if one of the parties is severely addicted to drugs, maybe they don't get much parenting time, and if they do get it, maybe it's supervised. All right. But all other things being equal, if you raise this to the court, they are supposed to award at least 25% unless they make findings as to why that's not appropriate. Parenting time is gender neutral. I cannot tell you how many times I've had somebody come in and say, oh, Minnesota is a mother's state, Minnesota is a woman's state. That has not been my experience. My experience is that the courts do as much as they can to make sure that gender biases don't creep in. I'm sure that there is the occasional case where that happens. All right, I have no doubt. But for the most part, I have not had this happen in my experience. I've been in front of a number of judges, and I found them all to be very cognizant of this issue. The age of the children is going to matter. The Minnesota courts put out a pamphlet. It's called Child Focused Parenting Time Guide. If you're looking at setting schedules, this is very helpful. It talks about what's appropriate at different ages, those sorts of things. And the trend in Minnesota is toward 50-50 if it's desired. Okay. And I have seen some research that suggests that on average, Minnesota is pretty close to 50-50 at this point. You know, maybe just not quite there, but very close to it. And my guess is that the state will continue to move toward this. A couple of other things that will get put into a parenting time schedule, holiday schedules. Okay, who gets which holidays are included? You know, if you're not Christian, do you even care if Easter's in there, for example? But you need to decide which holidays are going to be included. How are we going to structure this? Typically, people alternate yearly, but certain things like Mother's Day, Father's Day, the mother or the father is always going to have. And then vacation time. Very common to have either 1 week, 2 weeks, but then you have to decide, are these 2 weeks going to be consecutive? Are you only going to be able to take 1 week at a time? Those sorts of things. Once you get parenting time set, you get to move on to child support, because the amount of parenting time you get has a direct impact on how much child support you receive or how much you pay. Keep in mind that the right to child support belongs to the children. It does not belong to the parents. The parents get the money, but it is on behalf of the kids. And that means you cannot waive child support, right? You cannot say, well, if you give me an extra $100,000 of your retirement, I won't make you pay child support. Ain't gonna fly, right? The court will not do that. Payment of child support is a primary focus of the state because the state doesn't want to have to pay. The state wants to make sure that if parents can pay to raise their children, that they do so and that they contribute to it. The presumptive amount is going to be set by statute. All right. Now you can deviate up or down from this, but you're going to have good cause to do so. And if the court deviates from the presumptive amount, the court is going to have to make findings as to why it is doing that. We have this concept called PICS, parental income for child support. That is how you determine how much people pay. And it's based upon the gross monthly income of both of the parents. The child support amount is then based on the number of overnights per year for each parent. Now, until recently, what you had was either below 10%, 10% to 45%, and above 45%. And these were child support. If, for example, if you fell between 10 and 45%, you paid the same amount of child support. If you have 10% time, you have 45% time. That changed, let's say a little over a year ago. And now every overnight makes a difference for up or down the amount of child support. You can go online, and the Department of Human Services has this Minnesota child support calculator. Department of Human Services puts this out. You can just Google Minnesota child support calculator and you'll find it. The courts use this, attorneys use this. You fill in your information, okay? How many kids are there? How many non-joint kids are there? What is the monthly income for each of the parties? How many overnights are you getting? How much does insurance cost and who pays it? Those sorts of things. Once you put that in, you then click on it and it will give you a presumptive amount. And that is the amount that you are going to pay unless you have a good reason to go up or down from that. The main reason why we tend to see deviations, particularly deviations up, if you have a special needs child who has a lot of medical expenses, often the course will then deviate up. I do sometimes see agreements to deviate downward to help with cash flow for people who don't have a steady income. And the courts usually will accept that if it's not too much of a deviation. But you do need to have written findings if you're going to do that. If you have W-2 employees, this is a relatively easy thing. You can just look at the W-2, put in the gross income. If you have self-employed individuals, it becomes more difficult, but the statute does provide guidelines of what is and what is not included in self-employed income. And you can look at the statutes to find that. Generally, child support is going to be paid until the child turns 18, unless they're still in secondary school, in which case it can go up to age 20, right? You can also, if you have a special needs child, extend it beyond 20. We do have a client who has a 24-year-old with some severe cognitive disabilities. He is going to be defined as a child for purposes of the statute for the rest of his life. So child support will be paid until he dies. But other than that, that's very rare. Typically, it's going to be 20 at the maximum if they're still in school. The court cannot order payment of college expenses. I occasionally have people come in and ask for that. You can agree to that. All right, if the two of you want to say, hey, let's have an agreement that mom is going to pay the college expenses or dad's going to pay the college expenses, that's fine. The court cannot order that on its own, however. And as I said, occasionally people come in and they're kind of disappointed when they find that's the case. There are several different elements to child support or components of child support. And if you go to that child support calculator, it will break them out individually and then add them and give you a total. The first is what's called basic support. This is to cover the basic needs of the child. That would be things like housing, food, and clothing, right? That's what it's intended to cover. There's also what's called medical support. Each party is going to be expected to contribute to the insurance premiums, and each party is going to be expected to continue or contribute to the unreimbursed medical expenses. So, you know, if you have a deductible, for example, or you have a copay, each party is going to be expected to contribute to that. And that's based on those PICS percentages that I talked about. So if you make 70% of the combined gross income, you'd be expected to pay 70% of this. If you make 30% of the combined gross income, you would be expected to pay 30% of this. And finally, there's childcare support, right? If you need childcare for your child, that is also included. It does need to be for either work or educational purposes. Okay? You can have the other party contribute to childcare that you need to go to a job or to go to school. If it's for some other purpose, it is not included, right? These two purposes only. And again, this is based on your PIX percentages. Any question?
Yeah, I have a quick question because the definition of the income, and one is, someone that's on Social Security disability is a set amount that they're going to get,
Mhm.
and the child will get donates. But if somebody's a disabled veteran and 100% disabled, that's an amount that is not necessarily recognized correctly.
Yes.
The medical is covered, that's the thing for the child.
Mhm.
And I don't think that's usually captured either by the state.
Yeah, the question is about the definition of child support and submissions involving things like disabled veterans. Whenever you're dealing with somebody who's been in the military, the rules change. Doesn't matter what area of law you're doing, the rules change. For example, the Civil Soldiers Service and Relief Act, I believe is the name of it. You cannot bring a motion to change child custody while somebody's deployed, right? Kind of makes sense. You don't want somebody who's in Afghanistan all of a sudden getting notice that their spouse is trying to change custody, right? Same thing with a lot of payments that you get through the military. Military pensions, for example, are very different in how they're treated as opposed to non-military. If you have, anytime I get something involving really in-depth military, I like to push that off to somebody who knows a lot about it. The person I tend to point them to is Joanna Clybourne. She is, I believe, a major in the National Guard. She's been in the military for years. She's also a family law attorney. And if I have questions, I'll sometimes get a hold of her. Or if it's something really in-depth, I will just farm it out to her. And a lot of other attorneys do that as well, because it's really sort of a niche. Okay.
Would you say Minnesota law is keeping up with the evolution of that as we have more disabled veterans? Because I don't get
Law.
that impression.
Minnesota law keeping up with anything is kind of a question. Any law keeping up with anything is tough because you can't just go in and say, we're going to change it. Things take a long time. So I would say that, the law does evolve. It's just more slowly than we'd like sometimes. For example, that trend toward 50-50, if you were 10 years ago, we would have been much farther away from that. So law does change for depending on your viewpoint, for better or worse. But it takes time, unfortunately. Yes.
I have another question about
Yep.
calculating income.
Mhm.
If one or both of the parties has a salary that is based in a significant part on bonus
Mhm.
income, how do you calculate salary?
Bonus income gets included. Basically, you look at tax returns, you look at their year-end pay stubs. Sometimes you look at their bank account. They say they're only making $50,000, but they've got $200,000 moving through their bank account every year. Because income is any type of regular payment.
But if it's contingent upon the performance of the
You
company
average.
and it's.
Yep,
Okay.
you average. Sometimes if you have somebody who normally gets $5,000 a bonus and then all of a sudden one year they get 30,000 because of some anomaly, maybe you don't worry about that so much. But if they tend to get, this year they get 10, this year they get 20, and it fluctuates between those, typically what you're gonna do is average it. All right, let's turn briefly to the issue of spousal maintenance. This is much less cut and dried than child support. There is no website you can go to and plug in information and it spits out a spousal maintenance number, right? The courts have immense discretion in whether to give you spousal maintenance at all, and if they give it to you, how much and for how long. And on appeal, as long as they had some valid reason, it's going to be tough to overturn. Whether you think you got too much, not enough, too long, too short, it's very tough to overturn on appeal because of this discretion. It is supposed to be based on the marital standard of living. And because of this, budgets become very important. What was your budget during the marriage? How much were you spending on various things? Were you taking several European vacations every year? Right? That's going to play into spousal maintenance. Now, keep in mind that sometimes people live on credit cards. And so the lifestyle that he had during the marriage may not be something that you continue to support. And so the court takes that into account. If you were living beyond your means, they're going to recognize that. But it's supposed to be based on this marital standard of living. Spousal maintenance can be temporary or permanent. Basically, the difference is temporary, you have a set ending date in your decree. Permanent, there's no set ending date. Now, by statute, unless you agree differently in writing, things do end on the death of either party or the remarriage of the party getting spousal maintenance. Actually, 2 days ago, had somebody come in, didn't think I was going to be able to do much for them because they'd only been divorced about 13 months, wanted to change or modify spousal maintenance. Failed to mention to me initially that his spouse had gotten remarried 6 months after they got divorced. He is supposed to pay $1,000 a month for the next 12 years. I told him more money because you've already overpaid by $7,000, right? There's nothing in the decree that says you'll continue to pay after the marriage. So we're basically saving him $144,000 over the next 12 years. As I say, this was just a couple days ago. I'm going to be writing a letter either this afternoon or tomorrow to the other attorneys saying, oh, by the way, he got remarried, spousal maintenance is done. Hopefully the other attorney recognizes this and says, oh yeah, and contacts his client and says, sorry, because if we go to court, I have absolutely no doubt that we will win. It just takes time and money to do that. All right. We are going to talk about attorney fees.
Can you get your money back?
Yes. Yes, you can. You can ask for conduct-based attorney fees. And we're going to talk about that briefly just a little bit down the line. Either temporary or permanent maintenance is subject to modification or termination. If you have temporary maintenance that's supposed to go for 5 years, but you've been unable, even though you made a good faith effort, you've been unable to get employment, you can ask the court to extend it, and the court may. You have permanent maintenance, but you had an accident and can't work, you can go to the court and ask that it be modified or terminated. And often the court will do that. The length of the marriage is important. There's no formula, but length is a factor that the courts are going to consider, and we will look at some of these factors. In a short-term marriage, which we would consider 5 to 7 years or less, spousal maintenance is very rare. Not impossible, but very rare. As you get a longer marriage, the chances of getting maintenance increase, and the duration tends to increase. Okay, length of marriage isn't the only issue, but that's what happens. Oh, I should also mention, there is a way to make sure that things do not get modified, and that is through what's called a Karen waiver, K-A-R-O-N. It's from a case, Karen v. Karen. You can, by agreement, strip the court of jurisdiction to hear a modification. Typically, if somebody wants this, they are going to pay for it. Okay. One of the parties wants a Karen waiver because they don't want the other spouse coming back and asking for an extension. They may give them an extra $50,000 in retirement benefits or something like that, right? So if somebody wants to typically go and pay for it, but you can strip the court of jurisdiction to do this by agreement. Spousal maintenance is also gender neutral. It's going to depend on who makes more money. So you may pay money to a couple people. You may get money from a couple people if you want to go down this line. Hopefully that's not the case, but I suppose it keeps people like me in business. Now, although, as I said, there's no formula, the statute does provide grounds for an award of maintenance, as well as factors to consider. And there's a two-step process. First, you look at the grounds. If you meet one of these grounds, you can get maintenance. Then you move to the factors to figure out how much and for how long. So to be awarded maintenance by statute, you need to meet one of the following, okay? You don't have enough property that's going to provide income. And that might be, the court might ask, well, do you have investments that pay dividends? Do you have a rental property that brings in money? Those sorts of things. You're unable to provide self-support through employment. And here the question is going to be, are you reasonably employed or are you underemployed? Okay. Given your education and your background, should you be doing more than making $11 an hour at Target? Right? And if you're voluntarily underemployed, the court can impute income to you. And then the third reason is if you're caring for a child, typically somebody, a child who's very young or a child who has special needs, that would make it unreasonable for you to work outside the home. All right, if you have a child that needs pretty much 24/7 care, it's going to cost you so much more in childcare than you would earn anyway that it's probably not worthwhile. Okay. So if the court determines that, yeah, you meet the grounds for spousal maintenance, then they're going to turn to the question of how much do you get and for how long. And these are some of the statutory factors that they're supposed to look at. First, the financial resources of the parties seeking maintenance and the ability to meet their needs. So how much do you bring in and what is your reasonable budget? Budgets, again, very, very important. Now, just because you have a budget doesn't mean the court's going to accept it. All right. If you have $1,000 in dog sitting expenses every month, court's probably going to say, yeah, that's not really reasonable. Okay. But it's going to depend on your circumstances. And if you can show that, hey, throughout the marriage, we had a dog sitter and this is what we paid, then the court may accept that. Right? The time necessary for education or training. Are you in school and a couple years away from your degree? Well, maybe the court would say, okay, we're going to award maintenance for a couple years to allow you to continue as a student. The idea being that once you graduate, you'll get a job and you'll be able to pay your own way. Do you need 6 months to regain a certification that's lapsed because you were married? Things like that. And so that can play into it. Length of marriage, which we've already mentioned, the standard of living, loss of earnings, seniority, things like that. Did you give up a career when you got married? You know, whether you're male, whether you're female, if one of you gave up a career that, you know, maybe you were making $100,000, you had kids, the two of you decided, well, maybe you'll stay home to care for the kids. That can be taken into consideration when you're awarding spousal maintenance. Are you able to work? And if so, in what type of jobs? Okay, so age, health, physical condition, emotional condition, these things come into play. And then you have to look at the person you're asking to pay as well. Can that person meet their own needs while paying you maintenance? So can they afford it, right? You may have need, but if your spouse doesn't make enough even to cover their own needs, you're probably not going to be getting much, if any, in the way of maintenance. Excuse me. And the amount of maintenance is supposed to be limited to unmet need. So what is your reasonable need? What's that dollar amount? What is your income? What's the difference between them? That is supposed to be the upper limit of spousal maintenance. There are several cases out there where the court has said that maintenance is not a profit sharing scheme. All right. Just because somebody has money, you don't necessarily get it. If your need is $2,000 a month, but this person has $20,000 a month in available income, you don't get $10,000 just because they have it. All right, you just get the $2,000 because that's what's necessary for you to live at that marital standard. Right? And that's something that gets argued about a lot. Right, well, let's turn quickly to division of property. And I want to start out by distinguishing between marital and non-marital property. Because marital property is what gets divided unless there's a real need. They can invade non-marital, but it's very rare. Okay, marital property is something that one or both of the parties acquires during the marriage and before what is called the valuation date. Okay, valuation date is in statute because you have to figure out, okay, what date are we going to value these accounts as of, because they change every day. So the valuation date presumptively is the date of the first scheduled pre-hearing conference, or excuse me, pre-hearing settlement conference. In most counties now, that is going to be the date of the ICMC, or the initial case management conference. Now, you can agree to a different date. The court can change the date if it makes specific findings that that other date is going to be fair and equitable. And as I said, the ICMC is going to be the typical valuation date. We're going to talk about what that is. Some reasons why you might have a different date. Who remembers 2008? housing crash, okay? Let's say that your ICMC was in March of 2008, and as of that date, you had $150,000 of equity in your house that you could divide, right? By the time your divorce is actually getting finalized, it's December, and everything's gone to hell, right? I think it was August or September of 2008, housing just went like that, and it became very hard to get a mortgage. And let's say now, in December, you only have $20,000 of equity. Would it still be equitable for the court to divide $150,000 in equity that's no longer there? Maybe not. And so the court may change the valuation, at least on this one asset, to a new date. Similarly, let's say that you had an investment in some new company, wasn't worth a whole lot. All of a sudden, they come out with some product that everybody wants, and the value of the company goes up tenfold overnight. Okay, maybe it's now equitable for the court to change the valuation date to capture some of that for both parties. Okay, non-marital property is the other thing that's important. These are things that you acquire by gift, by inheritance, by bequest from, and this is important, a third party, okay, and to one but not the other spouse. If you give a gift to your spouse, that is marital property. If that gift comes from a third party and it's only to your spouse and not to both of you, that is that spouse's non-marital property. Inheritance is where we really see this. If parents leave their, their estate to their child, but not the child's spouse, that inheritance is now non-marital property, and the other spouse, barring some very rare circumstances, doesn't get any of it. This can be the subject of litigation. Let's say that shortly after you got married, you want to buy a home, your parents gave you $25,000 for a down payment, okay? Was that to just you, or was that to the two of you? And that's something that can be litigated because maybe the parents initially were giving it to both of you, but now they kind of changed their mind. But maybe you've got a letter that came with the check saying, here, this is for the two of you. We hope you enjoy your new home. Okay, those sorts of things become very important. So if it's to one person, it's non-marital. If it's to both of you, it's marital. Something that you have before the marriage is going to be non-marital. Something that you get after the valuation date typically is going to be non-marital. And if you have an antenuptial contract, a prenup, you can exclude things that otherwise would be marital. Now also, if you exchange any one of these first four things for something else, and you can trace it, it still stays non-marital. For example, let's say you had a home before the marriage, you sold it when you got married, got some money for it, put that money into a down payment on the new home. That portion of the equity, as long as you can trace it, would remain non-marital when you divide the home. Okay. So if you have marital property, how do you divide it? Well, by statute, the division is supposed to be just and equitable. Now, whether both parties see how it's divided as just and equitable is a little bit of a question, but that is how the court's supposed to do it. That does not necessarily mean equal, right? You can have something that is very unequal that under the circumstances might be just and equitable. In practice, a lot of times we do equalize. It's very common to have a marital balance sheet where you list the assets and debts and try to move things around so that you have an equal number at the end. Maybe somebody pays somebody else $2,500 to equal it out, something like that. But you can certainly have an unequal distribution if you can argue that that unequal distribution is equitable under the circumstances. And there are some statutory factors that you're going to look at when you do this. And this is not exhaustive, right? There are some others that I'm not listing, but these are the primary ones. The length of the marriage is going to be an issue. Age, health, and occupation, okay? If you're less able to bring in money or acquire property, you might receive a disproportionate share. The amount and the sources of your income, your vocational skills and employability. What are your needs? If you have a severe medical condition, maybe you need more of the property. And the opportunity to acquire assets in the future. let's say that you have two parties to a marriage. Excuse me, one is a stay-at-home parent and the other one is a business executive. And you're looking at retirement. Maybe that stay-at-home parent has $9,000, $10,000 in IRAs. This business executive has $500,000 in their IRAs and 401ks, but they're also more able to get additional retirement as they go on in their career. So maybe that stay-at-home parent gets 2/3 of the retirement because they're not going to have much of a chance to get retirement on their own in the future. Okay. Keep in mind that spousal maintenance and property division can impact one another because some of the property you might get might bring in income. You know, if you have a rental property, investments, those sorts of things. And so it's trade-offs and sort of a balancing act. Debt gets divided very similarly to property. You're not going to spend much time on this. It's just it gets allocated the same way, and it should be just and equitable. And again, it doesn't need to be equal. Some of the things that the court's going to look at, which party's better able to pay these debts? Was the debt incurred only for the benefit of one person? For example, student loans technically can be divided and allocated to both parties. Typically, most attorneys that I know are going to say the student loan should just go with the person who incurred it because they're the one who's going to benefit from it in general. But that's not necessarily going to be the case, but typical. Also, was the debt incurred without the knowledge of one of the spouses? We had a client who borrowed money from business associates and had promissory notes that were offering 10, 15, 18% interest, which brought in some usury questions. Spouse had no idea. Okay. The court said, hey, she didn't know anything about this. You borrowed all this money for the business. You're going to be paying it. Okay. He appealed it. The appeals court said, yep, you pay it. So that's how that can go. And then attorney, you mentioned or brought the question of attorney's fees. You can be awarded attorney's fees. In fact, family law is kind of unique in that it's not at all uncommon for one party to pay at least part of the attorney fees for the other party. There are two bases for the award of attorney's fees. The first one would come up with the issue that I was talking about before, conduct base. Something you did unreasonably contributed to the time, length, expense of the proceedings. For example, you're supposed to provide discovery. I make discovery requests, you don't send me anything. I do it again, you don't send me anything. But about the third time, I tell you, if you don't send me the stuff I'm asking for, I'm gonna get the court involved. You still don't send it to me, I bring a motion to compel. I'm gonna put in there a request for conduct-based attorney fees, and chances are pretty good that I'm gonna get them, okay? So the courts don't like game playing. You screw around, you might end up paying. The second is need-based. The courts tend to be very concerned that the parties have a level playing field. They don't want one party getting steamrolled because the spouse was able to afford an attorney and they weren't. And so they may ask, or they may order that one party pay need-based attorney fees for the other. There are three things you need to show to get this. The first one is usually not too difficult. Necessary for good faith assertion of rights. Hey, I need to have an attorney to be able to continue on with this and have representation and make sure I get what I deserve, okay? Second, the party you're seeking the money from has the means to pay, right? They have to be able to afford it. If they can't afford it, even though you might want them, you're not gonna get it. And third, you can't afford it. So if you can't afford to pay attorney's fees out of your own money, again, maybe you're a stay-at-home parent, and it's not uncommon for that stay-at-home parent not to have control of the checking account, unfortunately. And so they have a difficult time getting any money out. Maybe the other person puts it all in an account that they don't have access to, all right? They can ask for need-based attorney's fees. If you meet these three things, the statute says that the court shall award attorney fees, all right? So if you can meet this, the court is supposed to do it. We are getting a little short on time, but I do want to take just a very quick look at some of the, we're going to have to skip some of this, but the divorce process, there is no typical divorce. They vary widely in complexity, animosity between the parties, I mean, there are some people who can't be in the same room as each other. The difficulty of the questions being asked. I mean, I've seen divorces that from the time the petition was served to the time we got a judgment, it could be 2 months. And I've seen things go on for 5, 6 years, even more. It really is tough to say. Okay? As I always tell clients, the less I have to go to court, the quicker and the cheaper it's going to be. And I also tell them, don't spend $5,000 arguing about a $500 table. That's just dumb. Okay. Sometimes you need to, people get emotional and they want that table. Well, if it's going to cost you $5,000 to go to court to deal with this, don't do it. I did have one case where we resolved everything except for one issue. And we spent a day in trial arguing about the value of a 1967 Camaro that had been refinished. By my client was big into cars, and he did a lot of automotive photography for magazines, and he had this Camaro. He was good. He wasn't the greatest, but he was good. Could not agree on this, and unfortunately, the other attorney I talked, we really wanted to get this resolved because it was going to be dumb to spend $5,000 on a day in court about this, but we couldn't do it, and so we went to court. It unfortunately happens. I'm going to go through this very quickly. Things get started by services of a summons and petition. In Minnesota, most of you are probably aware, unlike most states, you start an action by service rather than filing. As a family law attorney, I really like that because we may not file at this point. Because maybe we can resolve things, or at least most of the stuff, before we get the court involved. Once you get the court involved, you're on the court schedule, not yours. Oh, I should actually, let me go back to this. If you do civil law, you probably know that a few years ago the law changed. If you serve an action in most civil cases, but you don't file it within a year of that service, it gets dismissed with prejudice. There's specifically an exemption for family law cases. Now, why is that? Well, let's say you serve, you're trying to work things out, all of a sudden a year has passed, you haven't filed. If this was the case, you'd effectively be prohibited from divorcing. Okay, so that's not going to happen. So family law is one area where that happens. You then file an answer and counter petition or serve it. You get 30 days. Again, this differs from the 21 days you have in most civil cases. Let me go through this very quickly. I do want to talk very briefly about the ICMC and the early neutral evaluations. The ICMC is the first thing that you're going to do if you file. About 3 to 4 weeks after you file with the court, you're going to have an ICMC scheduled. It's going to come with your notice of judicial assignment. It's informal. The purpose is to gather information. The court wants to know what the issues are, and they're going to explain the process to the parties. They're not going to make any decisions at this point, but if you do have agreements, you can put them on the record. Last ICMC I had, we were able to resolve temporary parenting time before we went in, so we did get that put on the record. And you're going to be offered the opportunity for early neutral evaluation, or ENE. I generally encourage this because they do have a pretty good record for settlement, at least partial. Also provides a first glimpse of how your client is going to do if you do go to trial and they're on the stand. Okay, you go to the CNE, they can tell a coherent story, great. They're all over the place and can't complete a sentence. Maybe you really want to settle this because you don't want to have them on the stand. All right, so this gives you at least the first glimpse of both of the parties in action. I think this may be the last couple things we get through here. The social early neutral evaluation, or SENE, and remember this is early, that's the first E. It's an attempt to resolve issues before the parties get too set in their positions and before they spend a lot of time and money. SENEs involve custody and parenting time. These are voluntary. The only way the court can issue an order for an SENE is if both parties agree to it. They're also confidential. Anything that's said in the SENE stays there. Okay, it's kind of like Vegas in that way. Well, not quite, but at least in that respect. In an SENE, you're going to have 2 evaluators. One is going to be male, one is going to be female. The purpose of this is to try, again, to avoid gender biases. So you want a male and a female to do it. They're going to listen to your story and what you want. They're going to tell you what they think is likely to happen if it goes to trial. And they're usually, in my experience, pretty close because most of them have been doing this for a lot of years. And then they'll attempt to mediate a settlement. These are set for 3 hours. You can have a second one if you need it. It's not particularly common, but you can. If you reach an agreement, the court gets notified of that. One of the attorneys is going to draft a stipulation. They're going to send it to the other attorney to see if you need changes, those sorts of things. If no agreement is reached, that is the only thing the court knows. And then you go back and just pick up where you left off. FE&Es, similar except they involve financial issues, maintenance, property division, attorney's fees, those sorts of things. Again, these are voluntary and confidential. Here you only have one evaluator. Again, they're typically set for 3 hours, but it's fairly common to have more sessions, especially if you've got a lot of financial issues to discuss. And again, if agreement's reached, you do a stipulation. If no agreement's reached, then the court is notified of that fact only. Any questions at this point? We're getting very close to the end. Okay. Then we'll talk very briefly about temporary relief motions because these become very important in family law. Okay. These can be brought once the E&Es are done, or if you don't have E&Es, they can be brought once the ICMC is over. And you're asking for a temporary order that is going to last through the pendency of the divorce proceeding. Okay, so until the judgment and decree is issued. If you want one of these, the statute says you have to have a parenting financial disclosure statement. This is 3 or 4 pages. It's sort of a snapshot of your financial condition. You're going to have to put a tax return, 3 pay stubs, those sorts of things with it as evidence. But it's just to provide a basic idea of what's going on. And it's going to be based on affidavits. Evidentiary hearings where you have witnesses are very, very uncommon in family law, except for things like contempt. Most motions are going to be based on affidavits and argument of counsel. So writing a good affidavit is very, very important. And then the typical issues that get addressed: occupancy of the home, temporary parenting time, temporary maintenance and child support, payment of the bills. You know, who's going to pay the mortgage? Who's going to pay the credit card bills? Are we going to divide it? How are we going to do that? And temporary attorney fees. And again, this can be very important if your client doesn't have much money of his own or her own, but the spouse does. You can go into the court early on and say, look, we're going to need attorney fees in order to continue representation and to do this. It surprises me that people don't bring temporary motions more often for this. Now, if the other side doesn't have money, I'm not going to tell that attorney, hey, you should bring a temporary motion. But generally, if your client doesn't have a lot of money, you should do this to try and address that early on so that you're not chasing $10,000 or $15,000 in attorney fees later and trying to collect them, because that is not fun. Believe me. We'll skip over discovery because we are almost out of time here. Do you want to, and if you want copies of the slides, I am happy to send them to you. I want to talk very briefly about vocational evaluations. These are something that we do have done fairly commonly, particularly if you have a party who's been out of the workforce, somebody has concerns that they're underemployed. You try to figure out what's their earning potential, do they need education training, so on and so forth. And this can be very important in spousal maintenance cases. You know, is your spouse actually earning what they should be? Either party can do these. I can have my own client take a vocational evaluation, maybe to show that he or she isn't able to work. I can have the other party take a vocational evaluation to show that he or she is, right? So either party can do this. Custody evaluations are not very common because they're so invasive, but in certain instances they do occur. We are at 1 o'clock, so I do have a couple more things that we're not going to get to, but I want to make sure everybody gets out of here in time. And I'm willing to stick around after and address things too. Any questions right now? Okay, well, what I'm gonna do is I will stick around, we'll end, but I wanna show you my website because it has my ancestors on it. So, all right. And again. Okay, you can contact me by email, by phone, whatever. This is my maternal grandmother and then her big ass family for a technical term. Thank you very much. So we didn't get quite through everything, but I hope it was at least somewhat helpful. Again, if you have questions or comments, here's my contact information, my phone number, my email, the website address. Feel free to give me a call or an email. I'd be happy to discuss with you and hopefully answer a question. If I can't, I do know somebody who has been doing this, former person I worked with, since 1955. Okay. Number is 4 digits as opposed to the, what are we at, 7 digits, 6 digits, 7 digits now? So yes, he's been doing this a long time and occasionally I have something I really don't know. I'll ask him and he usually has seen it. So thank you very much. Have a good day and I will stick around if you do have some questions. Okay.